Welcome to Pinsky Law Presents. My name is Brad Pinsky, and today we are continuing with part 4 of our series on fire department billing for ambulance services. This module focuses on understanding billing rates and rules. So today we're going to really make you a pretty good expert on understanding how to bill, what are the rules, what do certain words mean, what can you do, what can't you do. We're going to really give you a very expert level of understanding of billing rates and rules. So let's get right to it. As you hopefully now are very familiar with, the Fire Department Ambulance Billing Permissive Statute is General Municipal Law 209B, which says the authorities having control of a fire department that have authorized the fire department to provide ambulance services may fix a schedule of fees or charges to be paid by the persons, right? By the patients or the people requesting. So the question for you today is, how do we determine the rates? Well, state and federal law governs your billing rates. Most of the insurance companies and even the state works off of the Medicare fee schedule. So we're going to talk to you about the Medicare fee schedule. Now, there are a number of usual and customary fees associated with ambulance billing, and we have to become very familiar with the phrase usual and customary because we're going to use that a lot. So normal fees that we're going to charge are for the basic life support services and transportation. Those go together. Advanced life support at a ALS 1 or ALS 2 rate. Let me explain what that is. That means that the ALS provider is using a certain number of drugs. More drugs gets you a higher rate. So you go to a cardiac arrest, you get pretty much the highest rate they're going to pay. You can also bill, if you're an ALS provider, for ALS intercepts. You can bill, if you're the transporting ambulance, for mileage for travel to the hospital with a patient. This is called a loaded mile. You do not get paid for responding to the patient, and you don't get paid for coming back without the patient. You only get paid for a loaded mile, meaning the patient is in the back. And you might be able to get paid for treat and releases. Sometimes you bill this. Everyone asks me, well, should we? Well, it really depends. Look, not all treat and releases are created equal. You pick up somebody from the floor, put a Band-Aid on their forehead, as opposed to, well, I gave you some D5 and really did some, real intervention and got a real result. Maybe you can bill more and differently. Who answers this question? Go to your insurance company, because it is going to depend on a lot of factors. For one, what would they bill? And two, what does it cost you to bill it? And what do they think you're going to collect? If you're paying $32 and you're only billing $75, is it worth it? Yeah, it may very well be, or it may not. You're going to have to decide, but work with your billing company on that. Now, federal law, we have created a Medicare fee schedule. This was not always the case. Many years ago, over a decade ago, we had something called the usual and customary fee, permissive billing rate. And the usual and customary fees that were charged were whatever you charged and your neighbors charged, basically, for the ambulance service. And you would get paid the usual and customary rates in your area. Now, Medicare realized this wasn't really a good idea because everyone's just jacking up their fees to make the average go up. So that didn't really work so well. So what Medicare did is they said, you know what? We're going to come up with a fee schedule. And over 5 years of a blended schedule between the fee schedule and the usual and customary rates, eventually, and certainly by now, Medicare phased out the usual and customary fee schedule and now are 100% on a fee schedule. But if you're thinking, well, wait a minute, that's not fair. I'm in upstate New York and down in the Hamptons, that may be totally different, or vice versa. We're in the Hamptons, but way up in upstate New York, they don't collect as much. Understood. Medicare has something that equalizes the fee schedule to where you are and the type of environment, rural, city, urban, etc. And this is called the relative value unit. And Medicare increases or decreases, they adjust the fee schedule based on a number of factors with the RVUs, the relative value units, and it takes the base rate and adjusts it, right? Usually increasing it. And this is how they make it more fair depending on where in the country you are. The federal government's constantly updating the fees and charges. If you are dealing with, your best friend and your best friend says, I'm going to start billing for ambulance services, you're going to find out that dealing with a small billing company, not a good idea. Also, doing it in-house may not be a good idea. It's one thing if you're doing 2, 3, 4, 5,000 calls a year. Under 2,000, I don't personally think it's worth being your own billing company. Over 2,000, it may be worth it, but you know what? The billing companies provide so many good services now, why not use one? But you're going to see in a minute why I really suggest using billing companies and not doing this on your own, because you can buy software that will do your billing for you, but you're going to miss out on a substantial amount of very critical information coming up. So most billing companies know how to compute the average billing rates. This is my point. If I am a small billing company, I am not going to have the data to know what is a usual and customary rate in my area. Bigger billing companies, I'm not saying you have to go with the biggest, but bigger, more established billing companies have that data. And I'm not pushing any one billing company on you, but what I am saying is you better deal with a billing company who has substantial data on the usual and customary fees. Well, wait a minute. Is that really important? Is that needed? Because we're getting the fee schedule. Yeah, it's going to be needed for 2 reasons. I'm going to give you the first reason right now. We'll discuss the second reason coming up in a couple slides. The real reason you need to know usual and customary is because with Medicare, you do not simply get paid the fee schedule as adjusted by the RVUs. No. You get the lower of the fee schedule or your usual and customary rate. So your billing company better know your usual and customary rate. But we've got one other major consideration. Let's assume you say, you know what, we go to 1,000 calls a year, 100 calls a year, doesn't matter. And we're only going to bill for 10% of them. Why would you do that? Well, some places, especially on Long Island, have said, we're only going to bill, for example, for motor vehicle accidents. We're not going to bill for others. I would argue your usual and customary rate, the denominator of that equation, is still 100 or 1,000, whatever your calls are. But the numerator is going to be very low. Your usual and customary rate is going to factor in that you don't bill for 90% of your calls. So 90% of that equation is 0. I would argue your usual and customary rate is much lower than the Medicare fee schedule. So I do not believe it will be advantageous for you to waive most of your bills. Now, I don't think waiving copayments, as we just talked about in part 3, I don't think waiving copayments is going to make a hill of beans of difference, right? If you're legally allowed to waive them. If you're assuming them, no problem, you're still paying them. But waiving copayments, that's not the problem. But I do think in not billing for most of your ambulance services, could really bite you. So I'll talk about the second reason coming up. So let's talk about Part A, Part B, because you got to understand a little bit about this. So Medicare has Part A, which is called inpatient services, and Part B, which are outpatient services. If you are an emergency ambulance service, which almost all fire departments are, they don't provide general ambulance services, which might include taking a patient from a hospital to a nursing home, right? A discharge, or taking a patient from a hospital to an MRI and then back to the hospital if the hospital doesn't have an MRI, for an example. That's a Part A service. So let me explain Part A, Part B. And by the way, what I said about going from within a hospital back to the hospital, that's normally general ambulance services, right? The privates usually do that. It's not emergency ambulance services like responding to emergencies. That's what I believe general ambulance services are. There's no real good definition in the law. So that's for, 25 years what I've said it is. So let me explain Medicare Part A, Part B. Medicare Part A is that part of Medicare which pays for inpatient services. A hospital gets paid generally on what's called a diagnostic-related group, a DRG. A DRG is a set fee for a diagnosed condition, and Medicare and many other insurance companies using the DRG system will pay a hospital a set fee for a condition. For example, you go in, you have a broken femur. All right, and it's a shattered comminuted fracture. They map it out and they said, this is what it is. There's a diagnosis code for that. And Medicare, let's say we're on Medicare, will then pay, let's say $5,000. What they say to the hospital under this Part A diagnostic related group is they say, listen, we're giving you the $5,000 for the broken leg. If you can treat it for $1,000 and kick them out early, great, you made $4,000. But if it costs you $10,000 or $20,000, well, you're going to eat that. That's the risk that hospitals take when they take a patient for inpatient. They're only getting a set fee in most cases. When you transport as a general ambulance service, see all these phrases coming together? When you transport as a general ambulance service, a patient from in the hospital to out of the hospital who's not discharged, they're going back to the hospital or they're going to another same hospital property just somewhere else, right? So maybe they have two campuses and we're transporting to the hospital. But where the patient is not discharged, that's coming out of Medicare Part A, out of the diagnostic related group, the DRG payment. Why does that matter? It matters because you're billing the hospital. You are not billing the patient. You're not billing Medicare. If you transport an inpatient and they stay inpatient, they are not going to get personally billed. That is a Part A service. You bill the hospital. And how do you bill the hospital? You have to negotiate with the hospital. So here's my point on all of this. If you are going to do general ambulance services where you are taking non-discharged patients from the hospital to somewhere else and back to the hospital or to another campus owned by the hospital, this gets a little more confusing than that. But if you're going to take an inpatient and they're going to stay an inpatient, they're not going to be discharged as an outpatient, then you need to negotiate with the hospital directly. And you may or may not use your billing company for that. I still would, but you can bill them directly. But nonetheless, you should understand that's a Part A service billed directly to the hospital. Now, Part B services are for outpatient, like generally they're emergency services, not a general ambulance, it's an emergency ambulance service. And the Part B is where you're going to bill Medicare for outpatient or another insurance companies. So Medicare is easy. We've talked about Medicare. It's not easy. Frankly, it's one of the most complicated statutes out there, way more complicated than the tax code, believe it or not, but it is. That's why you don't dabble in this type of stuff. So that's Medicare. What about all the other times when we deal with a regular insurance company? Well, let's talk about that. You need to understand two phrases: participating, non-participating. Non-participating means I have not arranged in writing, subject to a contract, with a insurance company. I have not arranged to accept their set fee. Now, normally, there's a benefit and a not so good outcome of being a contracting or participating provider. If you contract with the insurance company, they're going to pay you probably quicker. You know what you're going to get paid. You don't have to argue with them. So that's all good. The bad, however, is they're probably paying you a lot less than if you are a non-participating provider. When you don't participate, when you don't have a contract, this is where the law kicks in, and we need to talk about what the insurance company will pay you. So let's do that. But just to know, insurance companies generally want to pay you at about 125% of the Medicare fee schedule. So that's, the Medicare fee schedule is the average of what we're going to collect, right? $325 on average for a basic life support call, maybe $425 on average collected for a ALS call. But nonetheless, the insurance companies look at whatever the Medicare fee schedule is as adjusted by the RVUs, and they're going to then come at around 125%. Well, that's a little too systematic to be fair all the time. So now you have to understand the terms usual and customary rates. The law says, now there's three laws. One governs insurance companies, the other governs HMOs, but three laws, I cite them below, 3216, 3221, and 4303 of the New York State Insurance Law. These require an insurer, if you're not participating, to pay a non-participating provider, you, if you don't have a contract with them, to pay for certain ambulance services at a usual and customary rate. Okay, fine. They have to pay you at the usual and customary rate. Who determines the usual and customary rate? Now is where you're going to see not using the ma and pa, local billing company, because the usual and customary rate is something that I need as an attorney who goes to court for you or goes to the state, or depends where we argue this, but where we argue on behalf of you that you're not getting the proper rate. This is where your billing company is witness number one. We need their data. Let me explain it. It is the HMO, the health maintenance organization, or the insurance company by law who determines what the usual and customary rate is for out-of-network ambulance service providers. Do you think they're going to come up generally with a rate that benefits you? Of course not. They want a lower UCR. How do we fight that? Well, if you're a non-participating out-of-network is another term, non-participating, non-contracted out-of-network provider, if you think the UCR rate is too low, then you need to contest it. Well, how do you know it's too low? Enter your billing company. Enter a good billing company, because a good, big, computerized with good databases and a great software, that computer company will be able to, billing company will be able to know what your usual and customary rates are for your area. Let me also give one thing. I am not pushing any billing company. Not my job. There are some very good billing companies. If you're upstate, there's great ones. If you're downstate, if you're midstate, great billing companies. But it will benefit you if you use the same billing company as many of your neighbors. Not as all of your neighbors, but at least as some of your neighbors. Why? Because we start collecting more data on usual and customary rates. And New York State, we have some data, but we don't have a huge amount of data. We have some data, certainly, from the privates and some of the not-for-profit ambulance companies who've been billing. We have some data, but generally, that's new. And Long Island, look, I'm very proud and very honored to have been instrumental in helping Long Island Ambulance Services really start billing. They hadn't been doing that for a while, and we pushed for many years to do that. But that's only recently. That's only in the last 3 or 4 years where we've really got a lot of the billing, a lot of the ambulance services to start billing. So we don't have a lot of good information on usual and customary. Your billing company can start collecting and sorting and analyzing that data. So what we would do is your billing company will say, you know what, these rates are horrible. They're underpaying you. And then we have to file a written complaint with the Consumer Service Bureau. And we ask the CSB to investigate the method and the rates that the insurance company is coming up with. But we need data to do that. And if we don't have a good billing company who has enough data and doesn't constantly track it, you're going to really be in a world of hurt. We're not going to be able to prove that the method's inadequate. So in that case, we really do need the data that a billing company would have. And we have to not only force the HMO or the insurance company to demonstrate its methods, we also have to have data to show those methods aren't producing a high enough accurate usual and customary rate. Okay. Let's talk about some other parts of the statutes. And I really hope you are feeling like you're learning, you're becoming an expert in this. This is really complicated stuff, and I hope we're doing a good job at, really giving you an understanding of billing. So let's go back to the law. The law says, and let me paraphrase a little bit, but we'll focus on the underlying portion. If the authorities who have control of the fire department, like the fire district, town, city, village, if they have authorized charging patients, note this last part. The authorities having control of a fire department or fire company shall adhere to any medical assistance enrollment and billing requirements applicable to such services prior to receiving reimbursement. What the heck does that mean? I don't 100% know, because I've never seen this language anywhere to know what it means. It is so vague as to be unhelpful. But look, I've been representing ambulance companies for 25 plus years. I should have some idea, so let me give you my best guess at what this means. First, does it mean that you have to be a participating provider? I don't think so. And in fact, I don't think you should participate to start. I think what this rule means, it's about balance billing, that you cannot balance bill. Let me explain to you what balance billing is and what this prohibition is, because it's a New York State prohibition that prohibits you from balance billing. And I'm going to go to a full screen and I'm going to show you what balance billing is. And I can only do it with my hands. So, okay, this up here is where you send the bill. And let's say you bill a patient for $1,000. The insurance company comes back and authorizes, let's say, $400. You are authorized to collect $400. Now, let's say below that, there's a copayment of, let's say, $50. So $350 is coming from the insurance company. They pay you. And $50 copayment is going to come from the patient. What's the balance that you're prohibited from billing? It's not the copayment. It's the difference between what you billed, $1,000, and what they agreed to pay, $400. You are prohibited by state law from billing the difference. That's $600. That is not to be confused with the copayment or deductible portion. That is not the same thing, I promise you. So that's what balanced billing is. Do not do it. I think there's only one case in New York that I'm familiar with, which took place in Utica. I won't mention the ambulance company, but it's public record. And the Attorney General has gone after an ambulance company for balanced billing. Do not do it. Do not send your residents a bill for that difference. Okay, so balanced billing is absolutely prohibited. I've discussed this. Copayments are not the balanced billing, so don't do it. I'll let you stare at this for a second. By the way, if you want any of these slides, every one of these lectures can be downloaded, and you can watch it always at your convenience. These are going to be up here forever, but you can also download these and take them with you if you don't have an internet connection and you want to watch them later. Okay, so the law goes further. The law says basically that you shall not directly, we'll come back to that word, you shall not directly issue a bill for your services to any uninsured recipient of your services. So if the patient has no insurance, they don't get charged. Fine, that part's easy. Now let's talk about the not easy. What about if they have Medicaid? No, that's still insurance. Medicare, still insurance. Any type of insurance is still insurance. Uninsured means you have no insurance. Well, what about they have a big deductible? No, they still have insurance. You can still bill them. They just have to pay the deductible. What about a copayment or other out-of-pocket? No, they still have insurance. You still can bill them. So what does this mean? This means they have no insurance whatsoever. Now, what if the claim was not medically necessary? We're going to spend a good amount of time coming right up talking about medical necessity. But what if the insurance company denies the coverage? Well, on the one hand, I would argue that the law prohibits billing because you're now uninsured. On the other hand, I would also argue, but you're not uninsured. You have insurance, but the claim wasn't insured. So are you an uninsured recipient? I would argue, and we can go both ways on this. I'm going to give you my answer. I'd argue, you know what? You're not uninsured. You are insured. Just the claim was not medically necessary, or the claim was denied for some reason. So if you want to know what to do, you can choose. On the one hand, you could say, you know what? We're going to interpret this as we're not going to bill because the claim's denied. On the other hand, you can say, well, we are going to bill you and send you a bill because you've got to pay the whole thing or part of it, but you don't have insurance covering it. You have insurance, just insurance didn't cover it. Why? For the main reason, as we're coming up, that it's not medically necessary. But before I get to that, we have to deal with another word. And I got to tell you, listen, I'm very thankful to everybody who helped make this bill come to fruition, this law come to fruition, but this language is just horrible. We got to clean this up. What does this word mean? You may not directly issue a bill for services to any uninsured recipient. Okay, so we can not directly issue a bill? I don't know what that means. What does it mean, directly versus indirectly? We can send it to someone else and say, hey, I'm handing this to you. Will you hand this to them? I honestly don't know what that means. And I can't come up with, 25 years of doing this. I'm trying to think, what could that possibly mean? I have no idea what that word directly means. I hope someone will explain it to us because it would allow us then to bill uninsured people indirectly. I don't know what that means. Okay, so I did want to point that out. Now, medical necessity. This is a big deal. We have to, whenever you write a report, we have to establish only with the report, the written EPCR, that the service provided was medically necessary. And that's going to cause us to have to learn how to write reports in a different way because we have never been trying to write our electronic PCRs, our reports, in a way that justifies collecting money. We have to relearn that. I'll get to that. So let me start with the law. Under the Medicare Act, which I quote here, Medicare will not cover services that are not reasonable and necessary for the diagnosis and treatment of an illness or an injury, or to improve the functioning of a malformed body member. Medicare will only cover patients that are medically, or only cover the patient's services, right? The ambulance transport, which were medically necessary. In other words, they were necessary to treat an emergent condition. But the second part of that is other transportation must endanger the patient's health and welfare, right? Other transportation must not be safe or reasonable. I'll give you an example. Somebody calls 911. Hello, 911. Hi, I cut my finger. Okay, we're going to send an ALS ambulance with 2 paramedics. Well, if that ALS ambulance transports that patient, and you've got a tiny little cut finger, and you're not on blood thinners or anything like that, where that cut finger could be a problem, you're going to have a hard time justifying how that trip is medically necessary and why you could not take a taxi to the hospital, which in fact is what we should be doing, getting a refusal and saying to the person, look, it's a cut finger. You do not need to go to the emergency room, but if you do, please take a taxi because this is not going to be covered by insurance and we're going to have to bill you directly or indirectly bill you. Who knows, whatever that meant. So we have to establish that the service was necessary. Okay, fine. Hello, 911. Hi, my femur is sticking through my leg. Oh, okay, we'll send an ambulance. Sure. When the ambulance gets there and transports you, you're going to say, wow, your femur is coming through your leg. We're not going to stick you in a taxi. That would endanger their life. So that is medically necessary. But if your report says, well, they had pain and didn't mention, well, their femur is sticking through their leg, we're not going to be able to prove medical necessity. So we have to learn report writing. But here's where I have to caution you. And if you use me to do, and use whoever, but if you use me as an attorney, as either a special or main counsel to do compliance training, this is one of the main things we're going to talk about. So, on the one hand, your PCRs need to demonstrate that the service you provided and the transportation you gave were both reasonably necessary and appropriate. And they were medically reasonably necessary and appropriate. On the other hand, you can't go so far as to start padding that PCR because that would be a felony. That would be fraud. So, for example, I have a cut finger. And I get there as a paramedic, the patient has a cut finger, and I get there as a paramedic, and I say, boy, patient, you have a cut finger. You really don't need the ambulance. And I'm thinking, but boy, billing hasn't been so good this month. We really need some money because I want a raise. Hey, do you have trouble breathing? It looks like you have trouble breathing. And the patient says, oh, maybe I do. I kind of feel short of breath. Okay, we're going to make that your main complaint. And we'll just put, you also cut your finger. Okay, that's fraud. In fact, that's felony fraud. You cannot create medical necessity. And I will tell you, as I will teach you, if you stay for our last module, as we're going to talk about some of the common billing schemes, if you create a false reason for medical necessity, that is a felony, and you and a whole bunch of people who should have or did know that you were fraudulently documenting your PCRs, they can in fact go to jail or be fined a significant amount of money. And I mean significant. We'll talk about that in the last module. So we have to teach our people how, on the one hand, to write good reports that document the actual medical necessity, and on the other hand, caution them, we are not telling you to create medical necessity where none existed. What if there is no medical necessity? Well, you should, not must, you should provide and have on your ambulance, your billing company could provide it, I can provide it. They're standard forms, and these are called Advanced Beneficiary Notices, ABNs. This form basically says, listen, we don't think this is medically necessary. We don't think insurance is going to pay for this. And you should know that you're going to pay out of pocket for this service. Again, I don't believe this means you're uninsured. I could understand the argument for it. There's some people who might make that argument. But I think this does mean you have a non-insured claim. The patient's not insured, but you have an uninsured claim, right? Because it's not medically necessary. You would hand them the ABN and you would say, listen, you're going to have to pay for this out of pocket. Please do not use ABNs to scare the patient out of reasonable and justifiable services. ABNs are not used for that purpose. They're just used to say that insurance may not cover it. They're also used for a couple other reasons. One is, well, we're only going to transport you BLS. I know you want ALS. I can't really come up with a good reason for this. You're probably not going to give ALS services if they're not needed. But nonetheless, if you said, well, you don't need this D5 because your sugar is not, wrong, so we're not going to give you the D5. We're just going to transport you BLS. And they say, oh, but I really, think it's an ALS service. Well, we're going to hand you an ABN. That's pretty rare, saying, well, we're downgrading. We're only going to pay for a BLS. Let me give you the one that will be more common, and that's an ABN with a hospital destination. So Medicare and most insurance companies are only going to pay for ambulance services for the loaded mile, right, when the patient's in back, transporting to the nearest appropriate medical facility that can give you the care you need. Think stroke centers in a minute. But if you decide to go, listen, I'm in Albany, but I really like Strong Memorial in Rochester, so that's where I want to go. If you decide to go there and pass a closer, more just as appropriate or appropriate medical facility, Medicare and most insurance companies are not going to cover that. Meaning you, the ambulance company, the fire department, are going to be out of collecting that mileage. You're only going to get the mileage to the closest appropriate medical facilities. So there is a good instance, one where if you're going to go somewhere else, you better document why the closest one was not appropriate. And two, this is where you might want to use an ABN, because if you said, listen, the hospital right down the street is perfectly appropriate, but the one 20 miles away, is also appropriate, but we're not going to pay for it. We're not going to get paid. You're going to have to pay us the mileage. Now you're going to hand them an ABN to say, we'll take you there, but you're going to pay that additional mileage. And then that then allows you to then bill them for the mileage from the closest appropriate hospital to the next hospital. Okay, so what about like stroke? Well, okay, so you have a designated stroke center. Look, if there are designated hospitals where you're told to bring patients, that's where Medicare and the insurance company should be paying you to take them. So if you have a stroke center, a trauma center, and that's where you have to go, that's where you should get paid to go, even if you're passing another hospital that's not appropriate for that condition. So I hope at this point, after the 4 modules, you are feeling really good, and hopefully you are feeling like you have some expertise and you understand terminology and you're starting to understand billing, and you know that you can do this. Sure, there's a lot of questions, but that's why we're here. That's why we're willing to help you, and that's why you definitely can do this. But if you have questions, please send them to us. If you email them to us, if they're a great question, we're going to do a Module 8, and we want to include it in a whole bunch of questions that you have asked. So we will use your questions to the benefit of everybody else. So please send us your questions and we will answer them. For now, I'm Brad Pinsky on Pinsky Law Presents, and we'll see you next time at Module 5.